How's it going, everybody? Welcome back to 2A News Now. And as always, I appreciate everybody that takes time to watch my videos. If you like the video that you watched today, and also you want to help the channel out and help it to continue to grow, I just ask you to take a few seconds of your time to like, share, and subscribe and hit those post notifications. I really would appreciate it. I think most of you know that if you want to purchase a firearm in the state of Illinois, you have to have what they call a FOID card, Firearms Owner Identification Card. And yesterday, an Illinois judge ruled that the state's FOID cards are unconstitutional when somebody possesses a firearm inside their home. This all stems from a case all the way back in 2017. The case was Illinois versus Vivian Brown. At that time, Brown was separated from her husband, and she owned a single-shot .22 caliber rifle that she kept in her home. And her husband filed a complaint saying she fired that rifle inside the home. But the police determined that the rifle had never been fired. But in true Illinois fashion, the state attorney actually charged her with possessing a firearm without having a FOID card. And here's what Circuit Judge T. Scott Webb had to say in his decision. After analyzing all the evidence in this matter, this court finds that the defendant's activity of possessing a firearm in confines of her own home is in fact protected by the Second Amendment. Additionally, there are no historical analogs to the FOID Act as required in Bruin. The judge went on to say, the court finds that any fee associated with exercising a core fundamental constitutional right of armed self-defense within the confines of one's home violates the Second Amendment. The court cannot reasonably construe the FOID Card Act in a manner that would preserve its validity, in addition to the finding of unconstitutionality, is necessary to this court's decision, and it cannot rest its decision upon an alternative ground. And here's what Richard Pearson had to say, and he is the Illinois State Rifle Association Executive Director. It is the height of hypocrisy for Governor Pritzker to sign legislation today claiming to protect potential domestic violence victims, while at the same time the FOID Card Act is being used to disarm those same potential victims. The state claims they need to charge $10 as an administration fee for the FOID card. The ISRA agrees with Judge Webb that the right to self-defense is just as important as the right to vote. Can you imagine if voters had to pay a $10 fee in order to vote by mail? Illinois Democrats would be up in arms about disenfranchising voters, but have no problem doing the same thing to firearm owners. Judge Webb did the right thing, ruling that Illinois FOID cards are unconstitutional. And the only reason that they have them to begin with is so they can have some type of a list of everyone who owns firearms, in which they could use somewhere down the line to use to confiscate those firearms. And now Vivian Brown, who was unduly charged, can now breathe easier that the judge ruled that this was unconstitutional. I'd like to hear your guys' thoughts in the comment section, what you think about the judge's decision. And as always, I appreciate everybody that supports the channel. You guys are always crushing it by liking, sharing, and subscribing, and hitting those post notifications, and I'm very grateful that you do so. And I invite all of you to come back and watch my next video.